The Independent National Electoral Commission, INEC, appears to have dashed the hopes and plans of many people when it declared it will not register any political parties, new ones, because they will not be able to participate in the 2023 general election by law. INEC, which claimed that the reason was because the new Electoral Act barred the registration of new political parties to participate in any general election 12 months before, added that the same new electoral law allowed for the merger of political parties only 9 months to the general elections. There are currently 18 registered political parties in the country. INEC National Commissioner in charge of Information and Voter Education, Dr. Festus Okoye, joins us now to put things in proper perspective. Welcome to this Live Sunday Talk Show, Dr. Festus Okoye. Thank you for joining us.
Yeah, thank you so much.
Okay, Dr. Okoye, you are the INEC Commissioner in charge of Publicity and Voter Education. I would like to receive from you, some, kind of voter education on this program today. Now, previously, Section 78, subsection 1 of the Electoral Act, that's the Electoral Act 2010, stated that, look, political parties can be registered 30 days to a general election. But in the amended Electoral Act 2022, Section 75, subsection 1, states very clearly that registration has to be 1 year ahead. And with the president, signing the act into law at the end of February, March 1, and all of that, it will look like, yes, the INEC has a point saying the time has already lapsed, so we should stay with the 18 registered political parties. But isn't this in violation of Section 40 of the 1999 Constitution? The Constitution being the basic law, the ground norm, and it's a notorious fact in law that a subsidiary piece of legislation cannot be superior to the basic law. So is INEC prepared for a raft of litigations, particularly now that you have some political groupings coming together saying that they will constitute a third force? What do you say to that?
No. You see, the Independent National Electoral Commission is a creation of the Constitution and the law. And we are under a constitutional and legal obligation to give effect to laws validly and legitimately passed by the National Assembly. Now, if you look at Section 221 of the Constitution of the Federal Republic of Nigeria, which is the fundamental law of the land, it makes it very, very clear that only registered political parties only registered associations can function as political parties. So, unless an association is registered as a political party by the Independent National Electoral Commission, such an association cannot function as a political party. Now, Section 75, subsection 1 and 2 of the Electoral Act 2022 has already come into force. The Electoral Act 2010 as amended is no longer a law of the Federal Republic of Nigeria. The law of the Federal Republic of Nigeria, as of today, is the Electoral Act 2022. Now, what the Electoral Act 2022 has provided is to give us the procedure and mechanism of registering political parties that satisfy the provisions in Section 222 of the Constitution of the Federal Republic of Nigeria. And this particular section was really a product of the consultations the Commission had with the registered political parties and also associations that were deregistered. They claim that if you register them 6 months to an election, which was what we had in the Electoral Act 2010 as amended, that they will not have enough time to campaign. They will not have enough time to set up their structures and so on. So they needed more time between the period of registration and the period of election for them to campaign. So this particular provision in Section 75 of the Electoral Act 2022 is a product of the political parties. It is their own making. It was the political parties that suggested that they needed a period of at least 1 year to prepare for a general election. So the provision is constitutional. It has nothing to do with a violation of the constitutional right of political associations, because the Constitution itself gives the National Assembly the power to make laws that will give effect to the provisions of the Constitution, and that will also set out the procedures and processes of realizing the intent of constitutional provisions.
Well, Dr. Okoye, I get the point that you have made. You've mentioned Section 221, 222 of the Constitution, right? But I drew your attention to Section 40.
Yes.
And as a lawyer, you must, you know, of course, that the Constitution is not, its sections are not to be read in isolation. They're to be read conjunctively. Do you foresee a situation whereby some of these political groupings that want to be part of a proposed third force will go to court and say that under Section 40 of the same Constitution, they have the right to the freedom of assembly, and that an electoral act cannot abbreviate that? If you can help me clarify that particular point.
The Constitution gives political associations the right to political existence. It gives us other associations the right to exist as associations, not necessarily as political parties. So if you want to exist as an association to canvass or campaign for certain interests, or to push some ideological directions, it is within your constitutional and legal right to do so. But if you look at Section 221 and 222 of the Constitution, these are specific provisions relating to political parties. So it says you can exist as a political association, but if you want to exist as a political party, you must satisfy the requirements in Section 222 of the Constitution. And it goes further to say that only political parties registered by the Independent National Electoral Commission can function as political parties and sponsor candidates to various offices as provided in the Constitution, and also campaign for such candidates. So what the Commission has done is not out of place. This particular provision has been in existence in the Electoral Act 2010 as amended. If you look at Section 78, subsection 1 of the Electoral Act 2010 as amended, it gives political parties that want to, political associations that want to transmute to political parties a period of 6 months to apply for registration. What this new law has done is to make that particular 6 months 1 year. So there's no contradiction whatsoever. It's already, the political parties are aware of this particular provision. And it is also the political parties themselves that imputed the Section 75, subsection 1 and subsection 2 of the Electoral Act 2022. You know that we don't have independent candidature in Nigeria. So all the members of the National Assembly belong to one political party or the other. So I believe that this is a law of the political parties. This is what they say they want. And as an electoral management body, we are under a constitutional and legal obligation to give effect to laws legitimately and legally passed by the National Assembly.
Okay, Dr. Okoye, isn't it the fact that the new law, as amended, allows for independent candidacy, and that the lawmakers rejected diaspora voting? Maybe I'm the one mixing it up, but I thought that was what I read. However, I'd like to ask you, in terms of its provisions, guidelines, and processes, what do you think of the new electoral law as amended? Do you think it will make the work of INEC easier or perhaps harder, particularly with regard to specific provisions? If I may just cite a few. Section 50, for example, that is talking about electronic transmission of results or the use of technology. Section 47, that is related to the right of displaced persons. Because anybody that is registered is supposed to go to a place of accreditation. And we have many persons who are IDPs. And then Section 54, I think, dealing with the rights of persons living with disabilities to vote. Now, do all of these don't they constitute challenges for INEC? What are the challenges? What are the positives for INEC?
Well, the Independent National Electoral Commission supports the intent of this particular Electoral Act 2022. The commission was part of the public hearings that gave birth to this particular Electoral Act. The commission was also part of the technical committee that considered the provisions of the act before the thing went, before the bill itself went to the National Assembly. We canvassed for some of the provisions that we have in the law as of today. In relation to even the persons with disability, we canvassed for that particular provision. In relation to the issue of using the number of accredited voters as a base for judging over voting, the commission was very firmly of the view that that should be the direction to go. The commission also canvassed the provision relating to the electronic transmission of results. So we believe that the bulk of the provisions we have in the Electoral Act 2022 are quite progressive and will also impute more firmly and more decisively the use of technology in the electoral process and enable us to reduce as much as possible human interference in our electoral legal framework and the electoral process. So we believe that the provisions do not constitute a challenge, but we rather aid the work of the commission and also make it possible for us to have free, fair, credible, and inclusive elections in Nigeria.
Okay, Dr. Okoye, but what are the challenges that you foresee? I mentioned section 47, which deals with use of smart card readers and other forms of technology, which also talks about the manner in which a person can put himself up for registration. And yet you have across the country persons who have been displaced. I know there is another section, section 24 or so, which makes provision for that. But would that be very challenging for INEC, particularly in certain parts of the country?
Yes, we have a cluster of persons who have been internally displaced in different parts of the country. Now, the challenge with that is that there are some of them who are living with friends, who are living with relatives, and also who are living in places where they cannot really be documented. So such persons will constitute a very huge challenge to the electoral management body. But for persons who are in the camps of internally displaced persons, in IDP camps, we are going to recreate their constituencies and recreate their polling units and make it possible for them to vote. We are also going to make sure that those of them that have lost their permanent voters cards, that we print new permanent voters cards and get them to vote. But for instance, if you are displaced from Imo State and you are living in the Federal Capital Territory, the implication is that you cannot be captured and you may not be eligible to vote in a state assembly election or in a federal constituency election or in a senatorial election that is constituency circumscribed. But if you live within the constituency and your IDP camp is within that particular constituency and you still have your permanent voters card and you are in an IDP camp, it's possible for you to vote. But in relation to the issue of electronic use of smart card reader or any electronic device, as you are aware, the Commission is now using the BVAS as an accreditation gadget or accreditation mechanism to accredit voters. Now, the challenge we have and the challenge we foresee is that because our elections are getting better, because we now make it impossible for people to engage in identity theft and for people to engage in multiple voting. Because some political parties and candidates and aspirants also know that some of our polling unit results are uploaded from the polling unit in real time. Violence is gradually returning to the polling units and leaving the collation centers. Before, the collation center was the battleground, but now it seems to us that the polling unit will be the new battleground because of the introduction of the BVAS and the uploading of the polling unit results in real time from the polling units. So we are taking that on board. And as you know, we also have insecurity of different dimensions in different parts of the country, and we will expect the security agencies to, as much as possible, either degrade or neutralize some of these security challenges ahead of the 2023 general election, so that the people can vote in an atmosphere of peace and without any fear or trepidation. So we are looking at some of these things as the challenges that will occur during the election. But we are preparing, and we are preparing well, and we are determined and courageous enough to give Nigerians a very good election in 2023.
Okay, Dr. Okoye, earlier on, I drew attention to the fact that Section 58, as the appropriate section, in the Electoral Act 2022, yes, talks about independent candidacy, and that passed, although diaspora voting failed. But in the light of Section 75, subsections 1 and 2, how is INEC preparing for independent candidacy? And persons who want to seek election without being on the platform of any political party, how should they go about it? And how easy would that be? Is INEC prepared for that?
Well, you know, the issue of independent candidacy and the issue of the registration of political parties is a constitutional matter. The Independent National Electoral Commission is under a constitutional and legal obligation to give effect to the provisions of the Constitution and the provisions of the law. So if perchance the National Assembly amends the constitutional framework of the country and brings into force independent candidacy, the Commission will be under an obligation to give effect to that. So when they do that and they bring out the mechanisms and the conditions and the requirements and the threshold that must be met for somebody to get on the ballot, the Commission will re-strategize and look at its regulations and its guidelines and then fashion out means and mechanisms of bringing that into being. So we, as of today, we are looking at the provisions of the law. But if the law changes, definitely the Commission will also change and the Commission will adapt to the new changes.
In other words, Dr. Okoye, are you saying that Section 58 of the new Electoral Act is inconsistent with the provisions of the Constitution, 1999 Constitution, and therefore, to that extent, null and void and of no effect whatsoever?
No. What Section 58 is talking about relates to who is qualified to vote and who is not qualified to vote, and the remit of the presiding officer when somebody who is legally registered comes to vote. What the presiding officer should do in such circumstances: one, the person must have his or her own permanent voters cards before the person can approach a presiding officer, and the presiding officer must use a smart card reader or any other electronic device for purposes of carrying out accreditation. That is what Section 58 is talking about, and it also talks about a removal of persons who try to constitute a nuisance from the precincts of the polling unit. That's my understanding of the provisions of Section 58 of the new Electoral Act.
Okay, so Dr. Okoye, are you saying that I mixed up the sections? Because it was widely reported 5 days ago that the National Assembly approved independent candidacy. So if it's not Section 58, I mean, you have spent probably more time with the new act. You can tell us what the relevant act is and then address my question accordingly.
No, the issue of independent candidature or independent candidacy is a product of the Constitution, of the Constitution. I am aware that as of today, the National Assembly has been voting on sections of the Constitution that has to be amended. So I believe that the Section 58 you are looking at relates to the new amendments that the National Assembly is trying to make to the constitutional framework. But in terms of the provisions of the Electoral Act 2022, Section 58 relates to the conduct at polling units. Okay.
Maybe you are saying this particular, issue is still an inquiry. But let me draw your attention to another section of the new Electoral Act, Section 3, subsection 3, which says that, look, the federal government has, or the whatever agency has an obligation to make funding available at least 365 days ahead of the general election to INEC. We've passed the 365 days threshold now, the president having given his assent. So, have you received the money in accordance with the law? When are you going to get the money? Because if you have not received it by now, it means that the law has been violated. I see you are laughing.
you know that this particular law came into force at a specific period, and as at the time it came into force, the 365 days imputed in the law had already elapsed. So I believe that the relevant authorities are abreast of the provisions of the Electoral Act 2022, and I also believe that those who are charged with releasing funds to the Independent National Electoral Commission and also doing other appropriations know about the provisions of the law, and they will do the needful. So we are already preparing. As of today, we have funds for carrying out so many of the activities we want to carry out. And I believe that in the next few months, all the other funds required by the Commission for carrying out all these activities will be released. So I believe that funding for this particular election will not be a problem. Our fundings are segregated into or compartmentalized to enable us carry out certain activities at certain periods. So I don't see funding as a big challenge in relation to the 2023 general election.
Okay, INEC has been talking about continuous voters registration. And we're told that, well, by June, that will end. But there's been, what has been the quality of response from the public to that exercise nationwide? Has there been, great enthusiasm about it? And I ask that question because of this perennial problem that we have with voter apathy in some of our elections, particularly in recent times.
Well, the response has been quite encouraging. And as you know, we responded to the agitation by especially young persons that they needed to use their smartphones and use the internet for purposes of registration. So we created what we call a pre-registration portal through which people who have attained the age of 18 and above, and or those who have not registered before, can go and interact with our portal and then carry out their pre-registration before going to go and capture their biometrics in either our state or local government offices. We also made it possible for those who want to transfer to do transfer through our portal, and also those who have any form of challenge or the other in terms of the data in their registration to also effect such change. Now, the response has been very, very good. Unfortunately, since the registration started, we have been carrying out this pre-registration online and also carrying out registration in our state offices and our local government offices. Now, we have not rolled out to the registration areas because we had a meeting with political parties, civil society groups and organizations, and the security agencies, and we were advised that we should hold on in relation to that for a while. Now, we have also had a new additional meetings with them, and we are set to roll out to the various registration areas on a rotational basis. But we are going to engage in a policy of rollout and rollback. If we roll out and there is no problem, we will continue the registration. If we encounter security challenges in any part of the registration areas, we will roll back to the local governments. But we are confident that when we roll out to the registration areas on a rotational basis, that more people will come out to register. So we are confident that before we approach June, that so many of our people who are desirous of registering will come out and register in mass. And I believe that the strategies we have adopted and the new strategy we are going to adopt, we aid registration and then put the thing closer to the people, especially in their various localities.
Well, Dr. Okoye, just before we wrap this up, I would like you to comment very briefly on the section 54 relating to provisions for people with disabilities. What arrangements are we likely to see? And then also, a lot of people complain about collation of results, issues at the collation centers. Is INEC prepared in that regard?
Well, in relation to persons with disabilities, we have been working with the Albino Foundation, we have been working with Inclusive Friends and all the other associations representing persons with disability in terms of gathering data from the various polling units relating to the types of disability that we have existing in different constituencies and in different polling units. And it's been quite helpful. We have been deploying assistive materials to the various polling units, but we want to know concretely where these persons living with disability are. So in the registration that we are carrying out now, we are also gathering that data, so that when we deploy assistive materials, we will be targeting the type of disability that exists in a particular constituency or in a particular area. So we don't have any serious challenge in relation to that. Some of them have been complaining about the quality of public facilities we use as collation centers and as polling units, and the need for us to provide ramps in some of these places. But you know, some of these public facilities belong to local governments and also belong to state governments. So we are going to be interfacing with the various state and local governments to see that they improve the quality of public facilities that we use as collation centers and as polling units, so that they will be disability friendly, and we can also make both the registration process and the voting process as inclusive as possible. Now, in relation to the issue of collation, I've told you that most of the political parties and the candidates now know that what happens at the collation center is just mathematical calculation, and that the real battleground is at the polling units, because the polling unit we upload the results of the polling units from the polling units, and we now use the beavers for purposes of accreditation. So violence has left the collation centers even before the presiding officers and the registration area collation officers reach the collation center. Nigerians are already aware of the results from the polling units. So as far as we are concerned, the more transparent we are, the more inclusive we are in relation to our elections. Our elections will keep on getting better. But I think that political parties must learn valuable lessons. There is no need trying to make our polling units ungovernable. There's no need trying to export or import violence to our various polling units. People should be allowed to go to the various polling units to again exercise their democratic franchise, because the vote must be given its due value. When you prevent people from going to the polling units, when you make it impossible for people to exercise their democratic franchise, what we are trying to do is to deny them of their sovereign rights. So the political parties should allow the people to exercise their democratic franchise without any due interference.
Well, thank you very much, Dr. Festus Okoye, Nigeria's Electoral Commissioner in charge of publicity and voter education. Thank you for your time.